we go along, and we'll be happy to address them. Otherwise, I think we will begin. It's 11 past 8, so we'll just begin. Just for joining us, we'll find us midway. Karibuni sana. I'll just invite Maulid to start us off on this session. Asante. Maulid, can you hear me?
Yes, Doreen, thank you so much.
Karibu.
Yes, good morning again, and thanks once again for joining us for this interactive session. So we have received quite a number of requests from our clients regarding the issue of land, especially now that there have been certain matters in court that have held that just a title is not a legitimate document per se, and that if its legitimacy is challenged regarding past history, then you do not hold a good title. So now we have shifted from the initial torrent system whereby a register of land was a conclusive proof of ownership, so that once you present as such at the Ministry of Lands, for instance, for you to check or confirm ownership, and you pay the charges for a search, and then you're given a search, then that search was a conclusive proof of ownership for you to now go ahead and complete a transaction. But courts have now shifted that position and say that a search in and of itself is not conclusive proof of ownership per se, and that you have to dig deeper and go to the root of title. So today we are discussing what the root of title entails, and some of the checklists that institutions have to have while involved in transactions involving land, taking of mortgages, and so on and so forth. So with that brief introduction, I will invite my colleague Rosemary to take us through the cases that are current right now. We'll discuss it, and then we'll go forth and discuss what going forward, how you can protect yourselves. So Rosemary.
Thank you, Maulid. Good morning, everyone. I think for many of us, this would be the first time we are meeting. I recently joined the firm as partner in the dispute resolution department, and therefore the issue of root of title is a huge concern for the clients that we serve, and we thought of preparing this presentation just to offer some sort of insight and guidance on how to maneuver, and also a reflection of what the courts have since said about the root of title. To start off, in terms of the cases being handled before the courts, I think the groundbreaking case was the dinner management case. If I could just take us to that case. The dinner management case is the one that dealt with the issue of change of title from public to private land, because it concerned public land in the county of Mombasa. And what they said then was that the introduction of the Land Act and the Land Registration Act changed the aspect that title is now a prima facie proof of ownership of land, but it does not guarantee absolute ownership. And that they took it from Section 26 of the Land Registration Act, which provides that a certificate of title is prima facie evidence that a person is an owner of land, subject to one, the encumbrances affixed on the title, easements, restrictions, or conditions contained or endorsed on the certificate. So what that means is that it's no longer a torrens system, absolutely, but rather a route of title investigation that needs to take place. And in the case at paragraph 97 of the judgment, they then came up with 6 aspects, or rather 6 steps or ingredients to prove that a title was actually issued procedurally. And the first step is that if land is going to shift from being public land to private land, the court said that there has to be proof of an application made to the chief land registrar for the allocation of public land. Out of that application, then follows a letter of allotment spelling out the conditions to be fulfilled. Once that letter of allotment is issued, although this is done contemporaneously, sometimes a part development plan would be prepared before the letter of allotment, but nonetheless, the two of them, a PDP, a part development plan, which is drawn and approved by the local authority of the area and forwarded to the director of planning, physical planning. So both the letter of allotment as well as the PDP is then issued to the director of physical planning for purposes of approval. And out of it then, a survey plan from the director of surveys is then prepared and issued. And out of a survey plan, you have the deed plan, and then you have the title deed issued. So those are the 6 steps that the court requires every property in relation to public land to follow. That first, we have the application for allocation of public land, the letter of allotment, a PDP prepared, and a survey plan, and then a deed plan, then finally a title deed. So where that procedure is not met, then the land is taken to have been illegally and procedurally acquired, and therefore the title would then end up being cancelled. And we find that this has then been a trend which is followed also in the Tarabana case. So the Tarabana case, they restated the aspect of certificate of title is merely prima facie evidence of indivisible ownership. But one thing I credit for the Tarabana case, which the dinner management case did not properly discuss, was that the issue of who is a bona fide purchaser or innocent purchaser of land was properly discussed. In that, the Tarabana case settled the whole aspect and said 3 ingredients must be met: the ingredient of innocence, the ingredient of purchase for value, and finally a legal estate vis-a-vis an equitable interest in land. They said that for proper title to move or be transferred, it must be based on a legal estate rather than equitable estate. And that is very important to note. One, because in succession, what needs to be transferred is the legal estate and not an estate that is subject to succession proceedings or subject to a trust, or subject to a caveat, or where assuming gift intervivals or a transfer as a gift was supposed to take place but was not completed or perfected, then whatever is transferred is not legal estate. And so if you have a title that was transferred without following the due process, it would then mean that that purchaser cannot be said to be an innocent purchaser, an innocent purchaser of land. Now, in the Torino case,
Rosemary, if I may, just a second.
Yes.
Kindly assist in moving the slides. I think we are not moving the slides so that everyone can follow you through.
Thank you.
Rosemary, sorry
Yes.
to interrupt. Kindly you can stop sharing yours. Let someone else do it so that it can move. Just stop sharing yours and you can proceed. Sorry for that interruption. Thank you.
Thank you. Sorry for that. Yes. So now we've discussed dinner management. We've now discussed the Supreme Court decision in Semi versus Tarabana, where they settled the whole aspect of who is an innocent purchaser of land. And now we go into the Torino case. We later see why these three cases are very important in understanding the whole aspect of root of title. So now the Torino Enterprise Limited versus Attorney General case, it began with a discussion as to whether or not the property concerned was public land or private land. And the court then saw that as soon as the title has been allocated to an individual, then the land becomes alienated land, which then means it's no longer under the purview of the Government Land Act repealed. So that means it is no longer public land. And so the question then moved to, does a letter of allotment confer interest in land? And the court held that where the conditions are fulfilled, then a title deed can be safely issued. But where the conditions are not fulfilled, then there cannot be transfer or conferment of interest in land. So that's one important thing that we need to always have in mind, that where you have a letter of allotment, the conditions must be fulfilled within the time permitted as per the letter of allotment. In this case, the conditions are supposed to be fulfilled within 30 days. However, the purchaser sought to do the same within a span of 127 days. So because of that lapse in time or variance in time, it was then taken to mean that the letter of allotment was not properly issued post the 30-day mark that was required. And therefore, the title then ended up being cancelled for that reason. Now, why is this important? I think we need to go back to Section 26 of the Land Registration Act. We've seen that the first part of Section 26 requires us to discuss the issue of prima facie evidence based subject to encumbrances, easements, restrictions, or conditions that are endorsed in the certificate, right? However, there's this other aspect where in the event of fraud or misrepresentation, and acquisition is based on illegality or lack of proper procedure or through a corrupt scheme, then the title will still end up being cancelled. So those are two limbs to Section 26. And the reason why I say this is because for me, I would then interpret that section to mean that the first part, this is encumbrances, easements, restrictions, and conditions, largely affect land in relation to private land. It will apply to public, but it's largely in relation to private land. And where it comes to public land, we then have the aspects of illegality, lack of proper procedure, or acquisition through a corrupt scheme coming into play. Why do I separate the two aspects? In relation to the public land, it's simply because there's a third party involved. Previously, it was the Commissioner for Lands who would then issue the necessary approvals, and a proper registrar would then issue the title, and that would then take us to the purview of indemnity in the event that the mistake was not occasioned by the purchaser or the borrower, but rather by the public officer, and that you actually find in Section 81, 82 of the Land Registration Act. However, when it comes to the private land, then the law does not seem to offer a solution to that effect. It's merely cancellation that would take place simply because conditions were not fulfilled, encumbrances, easements, and restrictions were not considered at the point of the transfer of land. I think for that now, I could pass it on to Maulid, because later on we will then see what next after all of this. Maulid?
Thank you, Rosemary. Yes, if we could quickly move to the next slides, kindly. Yes, so now we are going to consider takeaways that a bona fide purchaser must do today in order to protect themselves, to protect their finances and investment. So we begin by investigating the root of title beyond an official search. And then, so this means that you not only conduct an official search, but you start the process very early on, perhaps with a surveyor. You conduct a request for the registry index map or a cadastral map, as we shall see going forward. And then with that piece of map, you are able to locate the precise location of the property, as well as the size and the measurements and the demarcation of that property. And once now you have that through the Office of the Director of Surveys, you can then request for a green card search. So a green card search is a more detailed search as compared to an ordinary official search. And so on the green card, you'll find that it contains the history of all the land transaction done on the specific portion of land that you have an interest in. So normally the green card has 3 sections. You'll have part A of the green card, where it has it shows the property section, the date it was opened, the registration section, whether it's Nairobi, Kiambu, or Kajiado, and so on and so forth. It also has the parcel number. It has also the registry map sheet number. So from the RIM map that you had initially have, you can be able to confirm to the green card that the same number map is also consistent on the green card. And then you have the proprietorship section as part B, which normally has an entry number. It has a date. So normally it begins with the first entry from the history. So even if the title was in 1902 as the first entry, so it will have that date as entry number 1. It will have also the name of the registered proprietor. It will have the address, ID number of the registered proprietor, and then it will have the remarks by the registrar, whether it was a transfer or it was a lease or what have you. And then it must also have the signature of the particular registrar who endorses every entry. So every entry will have a different registrar if so, or if not, just the existing registrar will have to sign on each entry. And then on the third part of the green card, it will have the encumbrance section, which also has an entry number, the date that the encumbrance was entered, the nature of the encumbrance, whether perhaps it's a caution, it's a charge, or a court order, and then it will have the particular details of that charge, if it was a charge by Bank X, and the amount and the duration. And then it will have the signature of the registrar, and then the green card must be certified by a registrar, and it must be signed, certified, and dated. So and then now in some titles you'll find that they have a deed plan, which is encompassed by a cadastral plan. So cadastral plan is for Nairobi and maybe Kiambu. These are georeference approved plans showing boundaries. By that I mean it's digital data such as maps, satellites, aerial photos that are shown to a known coordinate system on the Earth's surface. So it's always also important to have a deed plan. which now will show the details also of the property and boundaries and all of that. If you can just return to the first to the previous yeah, the previous one kindly. Yes. So another important thing is the conducting physical site inspection, which is also very must. It's a very important step in conducting due diligence. So I saw a user on X who said that nowadays you have to even know the local drunkard for them to explain to you the history of the portion of title. So you must conduct physical site inspection, talk to the neighbors, buy the village drunkard some more, ujis, and then you can talk to the area chiefs and all that if there are religious institution nearby, just for your own heart contentment, because sometimes they're saying kwa ground vitu ni different, so you might find some information that might be so important that are not contained in any document. And then now you verify every encumbrances, even if they are unregistered. And then lastly, you say that the doctrine of innocent purchaser does not apply if the root of title is challenged, which in my opinion, I find it to be quite unfortunate, because to me, for instance, in the RTA, known as the registration documents that are issued under RTA, Registered Title Acts, which were generally issued for urban areas and where they normally issue a certificate of title. Yes, so in those instances, the RTA normally follows the torrent system, as Rosemary has captured. And so the, the the only major difference between the torrent system and the root of title is just the transfer of risk. So the risk is transferred from the state, whereby the state guaranteed the conclusiveness of a title. Now that risk is passed to the purchaser for you now to go to the root of title. And under the RTA system, the root of title is the green card search. So what if the green card searched, you have done it properly and it still has issues? For instance, a person at the registry perhaps changed files. Because in some instances we have found instances where there are two files, so that when you want to conduct a search, they'll say that the file is missing. But if someone with authority or someone who is known does the search, miraculously the files appears. So issues of corruptions means that sometimes, even as much as you'll do a green card search, the same might not be conclusive, and later on, it can be challenged, and then you lose your investment. And even though both now the RTA and the RLA have been repealed, and there's unification of titles under the Land Registration Act, major challenges still occur, especially also with the RD SASA, as we'll show shortly. So we can proceed with where we are, the slides. So what is the take home for buyers and financial institutions? So as we have said, we must verify the historical root of a title. Yes. And just a rider, the green card search is not available for all registration sections. The green card search, as I've said, is only available for RTA, because it's on titles under the Registration of Titles Act, that the history of the title is noted on the title. However, on the RLA, Registers Land Act, you'll find that there are no green cards for those. You'll only rely on searches. And if perhaps you have good contacts, you might request to peruse the original file at the land registry, which I would highly recommend. But for now that files in Nairobi are being closed as we migrate to the Ardisasa system, you cannot even peruse the original file. So that also is another challenge that Ardisasa brings to us. And then we have to agree that the letters of allotments are not title documents, and for you to rely on a letter of allotment alone so that you procure titles as you go forth, it might bring you challenges later on. And then financial institution must conduct physical site inspection to identify potential adverse possession, as I had said, and then due diligence must include a check for parallel deed files and a verification that the sequence of documents is chronologically logical. This one is also very, very much important. So sometimes once a land is allotted, then a plan is prepared from the cadastral map, because the cadastral map shows the entirety of, if it's a Nairobi region, it will show you. And then, so from that deed plan is extracted from the cadastral plan. And then from the deed plan now, you are able to form a title deed. So I'll ask my colleague to just take us through as we continue shortly.
Thank you, Maulid. As we go on, what is our other take home? In the event that the bank has to exercise its statutory power of sale, the bank must strictly follow the notice procedures for the sales, despite the fact that they are protected if they can prove a history of default, arrears, and unwillingness to pay. Reason for this is that when doing recovery matters, the owner of the property has always sought to challenge the statutory power of sale, particularly on the aspect of notices. They were not issued correctly, and that in itself just occasions the financial institutions further delay in the process. So due diligence would have to include verification whether there is pending litigation regarding the suit property. And this should also go on as far as existence of any court orders, existence of any succession claims over the property, because as we said, proper title can only be transferred where there is a legal estate rather than an equitable interest in land. That was discussed properly in the Marriott case, which was delivered, I think, quite recently. Next slide. So now the solution, I think at the beginning of this presentation, we had seen an excerpt of an article that was published sometime in 2025 about the cases out of the Supreme Court concerning the root of title. And towards the end of that excerpt, would find that the current CS for lands had stated that the Ardisasa platform would be a solution to the issue of root of title, simply because that all transfers would then take place through the platform. And that is fine. However, the fraud problem still persists. It does not validate the integrity of title. So a title whose root is tainted by fraud, illegal allocation, or identity theft will still likely enter the system as is. As indicated by Maulid a few moments ago, he indicated that the system does not permit for a green card search. And when you do a search on the title through the Ardisasa platform, you'd only see that they'll give you the last status, but it will not reflect the history of the title in relation to that title. Next slide. So millions of land records such as parcel files, mutation forms, deed plans remain undigitized. And perhaps that is the reason why when you conduct a search through the platform, you are unable to see the full history of the title. Right? And so there is no substitute for physical or legal inquiry. A clean and verifiable title deed does not discharge the duty to investigate the root of title, inspect the property, or verify competing interests. as he said, kwa ground ni different. In fact, there was a discussion as to the physical inspection of the land in the Torino case, where the court actually mentioned that since there was a physical attendance on the land, there was evidence of some military installations on the land, and that in itself should have shown that it was once public land. So that is the reason why, in as much as we'll do searches on the Athisasa platform, we would still very much require to attend to the physical and legal inquiries of the property. Next slide. So what can Athisasa do and what can it not do? It cannot, well, it can offer insert title verification in the sense that new titles carry a unique QR and barcode, and you can actually scan them. And when you scan them, it should tell you the reference number, the serial number, the land size, and even the registered proprietor. So if you're a financial institution and you have a title on hand, behind it, you will see some barcode at the bottom of the title. I think it should be on the bottom right. You would see a barcode of sorts, and in the middle at the back you would also see some sort of a serial a sticker of sorts that has a serial number to it as well. So those are the unique identifiers that come out of titles generated from the Athisasa platform. It has anti-counterfeiting features. So the new certificate includes the watermarks, the digital seal, I think that's what I've just referred to, and a standardized layout across all counties, making forgery significantly harder. You can no longer go to Kirinyaga Road to try and duplicate a title. Then unified tamper-proof register. So the land records are migrating from manual, decentralized files to a single digital system, accessible online and resistant to physical tampering. Next slide. However, what the platform cannot do is that it cannot validate the root of title. So it just digitizes existing records. So a title fraudulently obtained enters the system intact. So if there was something that, affected the title 20 years prior to digitization, whatever enters the system remains as is. A clean scan does not mean a clean history. So we cannot excuse a physical inquiry of the title. And then it also cannot replace physical inspection, and it cannot complete an incomplete archive. As we have said, mutation forms, deed plans remain undigitized. So for that, then it means an interrogation of the root of title through the platform is still not possible 100% through the Athisasa platform. Next slide. And therefore, it still cannot substitute legal due diligence. A clean Athisasa result replicates an official search. And the Supreme Court has already said that that is not enough, right? Maulid, if you can take us through the next part.
Thank you, Rosemary. Apologies, good people. I was just on the move. I have just settled right now. So if I can just take you through, so perhaps we can start with the RIM, the registry index map, so that we just see how it looks. Yes. So here is a registry index map for a title in registration section in Nairobi, somewhere in Hurlingham. So as you can see from the upper side, upper left side, so there you will have the coordinates of the place. So normally it will tell you the coordinates for the place, and then right down on your right, on the right, it will have the plan number, and normally it will have what is most important for us is the register number and the folio number. So this register number and folio number, they have to be consistent in all the maps, so that if there's any difference or there's any change, it will have to be entered in another folio number or a different registry number. So for instance, this property was subdivided. So initially, the two property marked in red were one and the same property, but they had to be subdivided. So on the subdivision, a mutation form has to be filled and then taken to the director of surveys. And then from the particulars of the mutation form, now a subdivision will arise. And then when a subdivision arises, the folio number down here will have to be different, because there were initially one property, now there are two. So the folio number and the register number will be different. And then now this register number and the folio number is what will be used now to get the new subdivided title. And then on the subdivided title, if we can now go back to the title. Yes. So here on the proprietary section on the right, you'll see there is cadastral map sheet number and cadastral plan number. So those two have to be consistent with the one on the registry index map. So you have to be very keen if there's any change, even if it's a one digit, for instance, it's 91 and here is 19, then you know that there is a problem with that property and you cannot pass a good interest. You have to investigate further, perhaps go to the director of surveys and then go to the lands office to see if it's just a typographical mistake. And if it's a typographical error, then it must be amended, and rightly so. If not, then it means that there's a fraud involved. And then also the edition number, you look at on the uppermost part of the proprietary section, it starts with it's edition number 1. So it means that the title is as is since it was first issued. So there have not been others that have been issued. And the date that it was opened, it's there. The registration unit is Nairobi. Registration section is Upper Hill, and then it will have the block number. This, I might say that this is a converted title. So if it was the previous title that was not converted, then the details will have been a bit quite different. So this is for a converted title. And you will see from the first page, the converted title, just as Rosemary has said, it has a unique serial number. So if you input this serial number, then it will bring you the details of this property. And then importantly, it will still has the title number, the area approximate in hectares or acres in some instances, and then the date that the transaction was done, as well as the seal and the signature of the registrar. So this is a certificate of title that has been converted. It's on the RDSASA system. So it has, just as mentioned, they have copied what exists under the green card. So because the green card has part A, part B, part C, it also has these features. And then you can see it has a barcode here that you can scan, and it will bring you the title number and all that. And so that's how an RDSASA title looks like. And then now, if on RDSASA, if the only challenge now is for banks that are trying to do due diligence in secrecy, then you are not able to do that, because for you to do an RDSASA search, you have to request. You send a request, and then the registered owner must look at that request and approve it. If they approve it, then your application fails on the spot. So we conclude with that remark and open to Q&As. Thank you so much, and have a good day.
Great. Thank you so much, Moha and Rosemary, for taking us through this presentation. I want to welcome anyone who has any question or any comments to add on to. Please feel free. You can either raise your hand and we'll be able to see you and give you a chance to say something, or you can type your question in the chat, but this is your moment. Please feel free to chime in here. Anyone on this call? Karibuni sana.
As the comments and the questions come in, perhaps we could
Yes.
also consider what next for financial institutions. One way of doing risk mitigation is perhaps ensuring that the insurance taken against the credit taken is paid up, that the premiums are paid up continually. So perhaps it would be a discussion as to whether to lump together the principal, the interest, and the insurance premiums together, because I know for insurance companies, asking them to insure the title deed, I mean, would be a germane issue for them to consider, but it would be a lot of risk for the insurance company to take on. But given that there have been several invalidated charges as a result of poor route of title compliance, banks then tend to be exposed. So one way would be to consider a lumping of premium, principal, and interest together. The other way would be to have blended securities. I know that's what usually takes place, where you have a charge and a guarantee signed, but in the guarantee, perhaps could be a change of wording, where banks would consider making sure that the guarantor guarantees that the title is actually good title and is in compliance with the root of title. I think then that when going after the guarantors, it would be based on a warranty issue as opposed to just failure of the borrower to pay up the premiums. Yeah, but it could be a larger discussion. We are happy to invite people sending us requests for an opinion to that extent. Thank you.
Thanks for that addition, Rosemary. Roy, asante for joining us this morning. You can proceed.
Yes, good morning.
Good morning to you.
Quick question. Now that Adisasa, as you have rightly put it, is an online registry, when we are conducting the enhanced due diligence for the root of title, how do we get access to the actual file at the registry? And is there one that exists anyway? Because obviously, yes, we can go to the Survey of Kenya, look at the deed plans, the RIM and the rest, but what about the actual files? Because as you've said rightly, as you've rightly put it, what is on Aritasa is basically a duplication of what was obtaining at the point when the property was then inputted into the system. How do we then go ahead and undertake that due diligence on the root of the title?
Yes, Roy, thank you so much for the question. Now, that's where the headache lies, because as you have said, once a title is uploaded and it's converted and is on Adisasa, the mother file, the original file, normally is closed. Because in some instances, I'll give you a scenario. So I was doing a transaction on behalf of a financial institution that was exercising its statutory power of sale. And then the title was in Karen and it was converted. And so when we're trying to do the application over the Ardisasa, we lodge all the documents as required. It's a lengthy process. However, it still needed approval and, in every step of the way, approval by the registered owner. And of course, they will not do that. And so when we tried to access so that manually, the registrar was really hesitant. It had to take us more than 2 months to get an inroad because the mother file, the original file at the lands was closed and you could not access it. And even application for manual approval of this process because the end user at the other side refused to acknowledge so that we could go ahead with the process. That was a very difficult process to overcome. Initially, there had to be compromises where we had to lodge manual applications as well as upload our requests online for the registrar to bypass the registered owner's interest on Ardisasa. So it still remains a challenge because right now, if you even ask for a green card search on Ardisasa, it still is not possible for you to do that. And if you request for a manual search, the information that you get is that that has been closed and is not available. So I think there need to be stakeholder engagements between all the relevant parties and the Ministry of Land just to air out these issues. We also have to give them credit because Nairobi was a pilot project, and these are the teething problems that we are facing currently. So, but I think with the stakeholder engagements, these are things that we can bypass. And my suggestion would be, you never know, Ardisasa might be hacked. And then people just lose their titles overnight. So even if we are closing the original files at the lands, then we are not supposed to dispose them or make them unavailable. They ought to be there indefinitely. So those are my long comments on the issue. Thank you, Roy.
Great, Roy. I hope that answers your question. I see on the chat there's a query from Anthony Mangeli. Maulid, he wants to know the map that you shared in your presentation. What type of map is that? Which map is that? Is it a RIM or a FR map?
Yes, that's a registry index map from the surveys of Kenya.
Okay, thank you. Gregory Okoth would also like a quick clarification on the Bakassi ranching land. Are there any systemic or historical issues related to the parcels? Public information indicates some issues. And secondly, do banks conduct due diligence? And he has a third question. Additionally, what are the average land rates for a parcel in Nairobi? That's from Gregory Okoth. If that was maybe your Maudi, take that.
Maulid, perhaps you can take the issue of the land rates. What is the average cost for the land rates for parcels in Nairobi?
So every parcel number, especially those that are based regionally, so you can get, for instance, in areas such as Westlands, so rates can go as high as 30,000 a year. In some instances, in some areas, it's peppercorn, depending also on the registration section and depending on the interest held. So for some absolute ownership, you'll find it's a peppercorn. In some leasehold, you'll find around 2,000 to 2,500. Even in registration sections such as Karen, I've encountered rates for annual rates of 2,000, 2,500, which seems to be the norm. But for leaseholds that are in Westlands, especially, I've encountered those that are quite expensive. So 20 to 30,000 in average, I might say.
Yes, and in relation to Embakasi ranching land, yes, there's still some historical issues that are not yet resolved. One, because I believe the origin of the whole system was started by as a society, and there are some trustee issues with mismanagement of funds, double allocation of plot numbers, and allotment of lands to shareholders. There are some court orders that are still being disobeyed, others obeyed. So yes, there's still some number of issues with Embakasi ranching properties. Although I believe a section of the area has been resolved, and I think there was a court order that certain people should get their titles processed. According to the information I have, do banks conduct due diligence? Yes, they do.
Okay. Thanks, Rosemary Maulid, for answering that. I see a hand up. Finley Muslimi, please proceed.
Thank you. I just wanted to know concerning the Ardisasa, whether it only applies for Nairobi, and if so, then is there a provision also for the manual applications for the charging when it comes to
Hello, sorry.
applications? Thank you.
Okay. Rosemary Maulid, did you get that in full? I seem to have lost a bit of it. Did you get the question in full?
Yes, there was a part where he asked if Athisasa only applies to Nairobi. I believe it doesn't. I believe it applies to other areas, such as Murang'a and Kiambu. Those are also areas that Athisasa is fully functional. However, there are other areas like I believe Narok. The remote areas are yet to be fully on the system. So manual registration, manual searches would still take place. However, the goal is to move the entire country to Athisasa. Unfortunately, there is no timeline that is offered by the ministry. So there is perhaps need to push the ministry further to ensure that this thing is done in 180 days, if possible. But yes, so Nairobi, Kiambu, Murang'a, I can confidently say is fully on Athisasa. Other regions are still being onboarded to the platform. Maulid, though, you can also confirm.
Yes, Rosemary. So Nairobi, 100%. In Kiambu, it's on Ardisasa, but for some certain transactions, you can still request for manual. The same also is ongoing in Mombasa, where it's dual. So you can there are some that are available on Ardisasa, but majority are still being onboarded, and it's a process that might take quite a while.
Great. Thank you so much for that. Is there any other question or comment? Anyone else wants to chime in? Yes, I only see your name as MG. Please proceed.
Oh, hello, my name is Maureen Gikaria, so the MG.
Karibu,
Mine
Maureen.
is maybe a clarification a little bit. Now that on matters of land history, because it is sensitive indeed. Now that with the Athisasa, we cannot be able to see the full history of the land, and the mother files are closed, the physical ones. Like, I would like maybe some more clarity on what is the best way to proceed in this matter moving forward, please. Thank you.
Yeah, thank you for your concern and question. It is a genuine concern, and we are also trying to figure out the best way, because as it is, it's quite an enormous challenge for every party. So what we'd recommend is the steps that we have said. So just try as much as possible to do manual search, even if it does not involve looking at the file, but look at site inspection, comments from neighbors, and all that. And then also importantly, if you have a council on record, then the council might request in writing to the registrar, so that you raise the issue that on our Ardisasa platform there is no opportunity for a green card search, and you would request due to perhaps the circumstances hold, that you would request a certified copy of a green card from the registrar. If they say that that one is closed and it is not available, then a guarantee on their end that the Ardisasa platform generally captures all the records as were retained in the old file. So this might be a challenge for them to approve, because it might pass on liability later on, but it will just show that you went out of your way to try and cure this issue. But I still maintain that a stakeholder engagement needs to be had, so that this issue will be raised. And going forward, I know this will be sorted. Otherwise, thank you.
All right. Thank you, Noah, for that. Anyone else with anything else they want to add? Karaoke Kingori, please proceed.
Yeah, thank you. And I am responding to what Rosemary was saying, and I thank you all for this presentation. Rosemary, you're speaking about getting guarantees, etc., from the creditors as a way of protecting ourselves as banks. But what we've seen is that, and even in this presentation on the issue of the root search of the title, we get to rely greatly on third parties. The assumption being that the lands registry, the director of surveys, are officers that cannot conduct or are not engaged in the problem, the root cause of the problem, and so we end up relying on information that comes from third parties who can give us fraudulent information. And therefore, it exposes banks to a lot of risks, either reputation or legal risks when we are trying to sell properties in the market. So I think either the form of keeptiness, you as a stakeholder, maybe you need to find ways in which you can respond back to the ministry and or explore ways in the penal code or otherwise as to how then banks can protect themselves or shield themselves from fraudulent acts performed by employees of the various government departments, which then bring us to these problems. Because in RDSSA, you will be transporting back the problems, you will be getting the problems, you'll be importing the problems into the system from the mother file, and there is really nothing much we can do as banks. We would want to go after the law firms and call up your professional indemnity, but still, even you could be innocent victims of the same searches. We will want to go after valuers, and even them, they could be innocent victims and consumers of fraudulent information. So I think there is need for us to interrogate this issue of the root cause as to where did the problem start, so that we deal with that problem, because we will be carrying over problems and exposing various third parties, say lawyers, valuers, banks, purchasers, innocent purchasers, to fraudulent acts, and where they're not necessarily the perpetrators or they're just victims. So I think there is need for us to sensitize the relevant ministry, whether it's the Ministry of Lands or whoever it is in government, that there's need to also have an look into their own systems and on their own people, so that they don't expose third parties to fraudulent acts. Rosemary, you're talking about getting more securities from our debtors. More often than not, banks will go for landed securities. So even if we get a guarantee, there's really nothing much you can do with a guarantee where you are exposed to 100 million and you had secured the facility using land in Nairobi, and now you're being told it was acquired illegally. Even if you were to sue someone under guarantee, I don't think much as you want to expose them to civil jail, you will still recover your 100 million. So I think there is need to go back and engage the necessary stakeholders. Back to you.
Thank you, Karaoke, for that comment. Yeah, it is definitely certain that recovering 100 million from an individual or a company would be very, very difficult. And yes, we are setting up meetings with relevant stakeholders to pick up this discussion further, even if it means going back to court to sort of bulletproof the provisions on indemnity. This is Section 81 of the Land Registration Act, so that we can make sure that where a title has been invalidated at no fault of the borrower, purchaser, or the financier, but purely at the fault of the registry, that the land registrar is then, the chief land registrar is then forced to pay up something as compensation. That provision has not been properly enforced in Kenya, but I hear in terms of best practice, Uganda is really huge on that. So that is something that we want to take it up. We are happy to have more in discussions on that. But that is definitely a move that the firm of KO Associates is willing to take. Yeah, thank you.
All right, thank you. I think I have time for maybe one more question. Gregor, I see your hand up. Please proceed.
Okay, thank you for your insights and the information you've shared in the slides. Now, I'm still on the peppercorn issue because I have interest in the Embakasi ranching properties. So the person who sold me the land, the lease certificate and title of lease, they were indicating peppercorn. So I recently received the SMSs from Nairobi County to pay land rates. So I was wondering, I have not completed the transfer process, but upon transfer to my name, will the title still remain peppercorn, or I will now start paying land rates, because you have indicated that for peppercorn you don't pay land rate. So in my case, once the title has been transferred to my name, am I now going to start paying rates? Because I'm already receiving messages from Nairobi County government.
Perhaps I can take that up. So Nairobi County is sending anyone with property that message. So it's not necessarily that you should pay, especially if you're already paid up. It's just a way of them reminding you to check the status on payment for whatever property that you have. But as soon as now the property is transferred to you and a title is issued in your name, there is definitely that likelihood that the rate payable would change. There is a likelihood. We cannot guarantee that it would still remain peppercorn. There is a likelihood they could actually change and put in a figure, because that is actually from the Ministry of Lands, really. And I believe there are new regulations to that effect, that even leasehold property would now be subject, as well as freehold property would now be subject to both rent and rates. So a different valuation is taking place from the ministry side. They're trying to raise funds for government. Yeah.
Okay, thank you.
Great. And Gregory, we're happy to discuss further. Maybe you could just give Rosemary a call or send her an email once we are done. Or you can just send me that and we'll be able to perhaps address any other queries you may have. And the same for all of us on call. We are happy to engage further, discuss further on any of the matters or the issues that have been discussed today. This doesn't have to be the end. So please feel free to reach out. You can just reply to the email invites that I had sent you. Or you can reach out to any of us here and we'll be happy to then engage further, because I know the topic cannot be adequately covered within the 1 hour that usually set aside, but we are happy to do that. I see there's a question from Anthony Mangili in the chat. Gregory, what is included in the title is ground or rent land rent, but not land rates. There's a difference. I think this was just to clarify further on the question that Gregory Okot had asked. So Anthony, thank you for that. I hope that's also been well taken. Yeah. So I think we are in good time. I do not want to take too much of your time. I probably want to bring it to a close unless there's a really burning question or comment that one wants to put in. All right, I think we are well taken care of. But as I've said, please feel free to reach out. We are happy to engage further. And thank you so much, all of you, for taking your time as usual to join us. We really appreciate your presence and we appreciate your input. Please feel free to also reach out and let us know the areas that you might want us to delve into further or to discuss maybe in future webinars. We'll be happy to consider those. But otherwise, thank you so much for your time. Rosemary and Molly, thank you so much for taking us through this presentation. And to all of us, asante sana for joining us again this morning. Please extend our invites to your colleagues for future webinars. We have them every month, usually either the 3rd or the 4th Tuesday of the month. So you're very welcome to join us. Otherwise, let me wish you a lovely day ahead and the rest of the week. Asante sana. Do have a blessed day. Thank you.